Digital technology has made it very easy to copy and reuse works that others have created. And it has made it easier than ever to create and share your own work. Basically, copying and hence copyright is everywhere. Since we do a lot of work online, more so in these days of the pandemic, our online work nearly always involves making copies. And hence we need to understand copyright and the law governing it, since they play a major role in our online presence. As one who believes that content should be free, we need to understand copyright to appreciate that the CC licenses ride on the copyright laws. What is copyright? And why do we have copyright? Copyright is the law that protects creative works. Protection from what, you may ask? Well, it prevents others from using your work without your permission. Copyright also gives you rights over your work and allows you to make money out of it. Hence, if you have copyright on your content, you can make multiple copies and distribute and sell them. You can translate them, modify them, adapt them, turn it into a play or a movie or even a comic strip. If it's visual content, you could display your work in a museum or in an exhibition, be it photographs, paintings, or even sculptures. If it's a play or a piece of music, you publicly perform it. But something to think about, is copyright perennial? Before I go into that aspect, let's look at where copyright begins. Well, it begins the moment your creation becomes tangible. So, the moment you write your first stanza to a poem, or you click a photo, or create anything that is content, be it text, image, video, or music, it is under copyright. Hence, copyright is automatic. For creations that are independently created, are novel, and from the moment the creation finds a tangible expression. And what's a tangible expression? Something that's written down, recorded, posted on the web, or even saved on your computer. If any of these things happen, the copyright becomes effective. Let's also see what copyright does not cover. So, ideas, facts, and figures cannot be copyrighted. Only the works that are created using them can be a creative expression and hence can be copyrighted. Can you think of any situation that you don't have copyright on the content created by you? This can happen when you work for hire to create something, or you work in an organization or an educational institution, drawing your salary from there. In such cases, the institution may have a policy that says that the institution has copyright on the content you created. Humankind has always been creative. There was so much of literature, paintings, music, and artwork in the past. And obviously, there was no concept of a copyright till about 3 centuries back. It was only in 1710 that the first Copyright Act was made. The main aim of the Act was to encourage learning and for authors to get incentives to create more. The Statute of Anne was created in London. The Copyright Act initially extended the copyright for a period of 14 years from first publication, extended by another 14 years. Also, initially, copyright was only given to the printed works, mainly for literature, and to the cartographers for the maps. With time, this period of 14 years got extended many times over. At present, almost anything that is tangible product of your creativity can be copyrighted. The list covers books, music, painting, photographs, plays, maps, architectural works, movies, pantomimes, choreographic work, sculptures, almost anything that is a tangible product can be copyrighted. Soon, as countries started drawing up their own copyright laws, and since people started traveling, questions about which laws would apply where started coming up. There was a need to come to some consensus across countries on copyright laws across the world. The Berne Convention for Protection of Literary and Artistic Works is an international agreement governing copyright and was first held in 1886 in Bern, Switzerland. Since then, the convention is held regularly by the World Intellectual Property Organization, WIPO. One of the things that the convention ensured was doing away with the need for registration of copyright. Imagine going to the registrar's office to register your copyright every time you clicked a photograph or wrote a short poem. But some countries still require registration in case of litigation. Although an international framework exists because of the Berne Convention and other treaties and agreements, the copyright law is enacted and enforced through national laws in each country. That means each country makes its own copyright laws. The convention also recognized that each country needs to honor the copyright laws of the other countries. In case of movement of people or works, the copyright law of the country in which the work is published or performed applies. The Berne Convention helped to set minimum standards of copyright law. All works except photographic and cinematographic shall be copyrighted for at least 50 years after the author's death. The Copyright Act started with 14 years of publishing and it has reached 50 years after the author's death. For photographs, the minimum term of 25 years from the year the photograph was created, and for cinema, the minimum is 50 years after showing or 50 years after creation. Though there were common minimum standards, countries were free to enact their own laws. Here is a map of the world showing all the countries that are a part of the Berne Convention as of 2012. As of 2018, there are 176 countries, while today I believe there are 178 countries that will have signed the Berne Convention. Hence, different countries different standards. Let's look at two countries. In US, the copyright term lasts for the life of the author plus 70 years. And for anonymous works or pseudonymous works or works made for hire, the term is 95 years from publication or 120 years from creation, whichever is shorter. Compare this with another country where the copyright is for a term of life of the author plus 60 years. And for posthumous works, photographs, cinema, sound recording, works of public undertakings, and works of international organizations, it is 60 years from publication. And this is for India. What happens when copyright expires? Thankfully, copyright is not permanent. It expires as the period ends. So, copyright protection is automatic on creation of a work, and when the copyright's term ends, the work passes into public domain. Public domain consists of creative works that are not subject to copyright. So, it's a pool of publicly available material from which new creativity and knowledge may be built. A healthy public domain is absolutely crucial to preserving our cultural heritage and to inspire new generations of creators and increasing human knowledge. After expiration of copyright, the books that come into public domain may be copied and sold even for profit. You may use it even without attribution, but it would be ethically correct to give credit to the original creator and author. Creative Commons has a tool, public domain mark, for labeling works whose copyrights have expired. Since 2016, this public domain tool has been used to mark 90 million works. Mahatma Gandhi's work came into public domain in January 2009. If you remember, he passed away in January 1948. So, 60 years after that, all his work came into public domain. Similarly, Rabindranath Tagore's work came into public domain in January 2002. He passed away in August 1941. Now, is that the only way that materials can come into public domain? By expiration of the copyright? No. Authors can choose to forego their copyright and dedicate the content created by them to the public domain and license it CC0. It's called public domain dedication. It helps authors put their work into the worldwide public domain to the greatest extent possible. Also, there are some kinds of works that cannot be copyrighted. For example, works purely functional, say a screw, or official texts, legislative or administrative, or rules or regulations, as also facts and figures. Some sites that host public domain are very popular. For example, the Project Gutenberg, Wikimedia Commons, Internet Archive, and the Flickr. IP or intellectual property is the term used for rights established by law that empower creators to restrict others from using their creative works. Copyright is one type of intellectual property, but there are many others, and important among them are patents and trademarks. The patent law gives inventors a time limited monopoly for their inventions. Things like a new electronic device, a new high yielding variety of a crop, or a new technology, or even a different way of processing food can earn patents. Patents typically give inventors the exclusive right to make or get it made, to use or get it used, sell or get it sold, their patentable inventions. Hence, patents protect an idea while copyright protects the expression of an idea. Trademark law generally protects the public from being confused about the quality and source of a good, service, or an establishment. The trademark helps identify the company that made the product, and it is generally associated with quality, of course, good or bad. The holder of a trademark can prevent others from using their trademark, and the law helps producers of goods and services protect their reputation, and it protects the public by giving them a simple way to differentiate between similar products and services. Coming back to copyright, you may be happy to know that copyright is not absolute. So that public rights were not unduly restricted, the Copyright Act has some exceptions and limitations built into it. These allow the critic to write a review on a book, a play, or a piece of music, allow a cartoon or a stand up artist to quote from it. In case the textual content was not modified for visually disabled, they would not get access. So, some of the uses for public use are taken care of by way of exceptions and limitations to the Copyright Act. Also, imagine if teachers and students couldn't quote from a book or an article, or if Google searches yielded nothing, since blanket copyright would not allow snippets to be extracted. In order to maintain an appropriate balance between the interests of the people who hold the rights and the users of the protected works, copyright laws allow certain limitations on economic rights. That is, conditions under which protected works may be used without the authorization of the right holder and with or without payment of compensation. Hence, there are some uses of copyrighted works that do not require permission. These fall under exceptions and limitations to copyright, fair use, fair dealing, and other exceptions and limitations to copyright are an extremely important aspect of copyright design. If you use another's copyright work in a fair manner, or if it falls within an exception or limitation, then you are not infringing on the creator's copyright. As per Copyright Office, Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India, and the Indian Copyright Act, certain acts are not considered to be infringement of copyright. They include a fair dealing with any work not being a computer program for the purposes of private or personal use, including research, criticism or review of any work, the reporting of current events and current affairs, including maybe reporting of a lecture in public. As an organization and as a movement, Creative Commons believes in content being accessible to all. It strongly supports strong exceptions and limitations to copyright. Creative Commons supports a copyright system that appropriately balances the rights of creators and the rights of users and the general public. Thank you.